The ruling will not take effect immediately. Attorney General Rob Bonta says he'll appeal the decision.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
A federal judge struck down the California law. The judge ruling that law was unconstitutional.
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
Ammo Inc. constructs a factory to satisfy America's endless needs. As American consumers contend with a continuous ammo scarcity brought on by the country's unparalleled demand for arms, ammunition maker Ammo Inc. is constructing a new factory. While arm owners are happy to hear of the opening of a new facility, the issue of excessive demand versus supply this year won't be resolved by it happening quickly enough. In June 2021, Ammo Inc., based in Arizona, began construction on a 160,000 square foot manufacturing plant located in Manitowoc, Wisconsin. For arm aficionados who have been searching arms stores for ammunition and finding empty shelves, particularly for popular calibers like .22 for target shooting, 9mm for arms, and .223 for AR-15s, there is hope thanks to the opening of a new plant from a startup American manufacturer. According to a local television broadcast, Ammo Inc. Chief Executive Officer Fred Wagenhals made light of the fact that he was the only co-founder who knew what an arm was during the groundbreaking ceremony. The firm intends to complete the project in 2022 and create 300 employment opportunities in the community. In response to messages from Forbes, Ammo Inc. did not reply. The groundbreaking, which was also witnessed by Ammo Inc. board member and former NASCAR driver Rusty Wallace, looks to be happening at the right time. Since the coronavirus outbreak hit the nation early last year, Americans have been purchasing millions of arms and hoarding ammunition. The Federal Bureau of Investigation's background checks and the financial reports of top arm manufacturers, Smith & Wesson and Sturm Ruger, indicate that arms sales have reached all-time highs. According to Rommel Dionisio, an Aegis Capital arm industry analyst, they're certainly riding a historic surge in consumer demand for ammunition in the past year, following the spike in U.S. arms sales since early 2020. Furrows about the possible tightening of arm control legislation under the Biden administration are driving heightened consumer fears that initially drove arms sales due to increased concerns over personal safety following widespread civil unrest. Democratic President Joseph Biden has been preparing to take tough measures against semi-auto arms, sometimes known as assault weapons or modern sports rifles, produced by numerous businesses like Smith & Wesson and Sturm Ruger. He also targets high-capacity mags, such as those produced by Magpul, ProMag, and other firms that have a capacity of more than 10 rounds. AR-15s and other assault rifles have been used in numerous mass slayings. Glocks and other arms have also been used in mass slayings. However, the U.S. military also carries AR-15s, while Glock arms are favored by law enforcement personnel. Although there is strong support for the arm control movement, there is also strong opposition. A federal appeals court recently invalidated federal laws that would have prohibited the sale of arms to individuals under the age of 21, citing Second Amendment violations. In addition, arm control supporters disagree with Biden's selection of David Chipman to head the Bureau of Alcohol, Tobacco, Arms, and Explosives because of Chipman's previous position as an advisor to Giffords, the arm control organization that was started by former Arizona Representative Gabby Giffords. Giffords, a Glock owner, was hurt in a mass slaying in 2011 by a man brandishing a Glock and a large mag. Fear is another factor driving arms sales because the coronavirus shocked the nation's economy and resulted in violent riots, armed crime, hate crimes against Asian Americans, and Capitol storming. Millions of Americans, including an increasing proportion of women, Asian Americans, and Black Americans, have purchased arms for self-defense.
The ruling will not take effect immediately. Attorney General Rob Bonta says he'll appeal the decision. California cannot ban gun owners from having high-capacity gun magazines.
Ammunition sales are usually strong when arms sales are strong. If only stores had more goods to sell, several told Forbes, sales would be even higher. However, customers will have to wait a little longer if they are hoping that the ammo shortage will ease up. Building an ammo factory requires at least 6 months, according to Dionisio. There are environmental and waste issues to consider, in addition to the installations of machinery, production lines, warehousing, and shipping infrastructure, Dionisio stated. The pandemic and a global shortage of basic materials like copper had already crippled the supply chain, which is now under pressure from the continued demand. Founded in 2016, Ammo Inc. went public in 2017 and was given the NASDAQ ticker POWW. Year to date, the stock price has increased by almost 100%. Analysts at Roth Capital began covering the company in April and recently raised their target price from $9 to $11, recommending a buy for the business. The groundbreaking by Ammo Inc. comes after another significant development in the ammunition manufacturing sector in 2020. Vista Outdoor, the top American ammunition manufacturer, bought an Arkansas ammunition facility from Remington. The storied arms manufacturer Remington has twice declared bankruptcy under Chapter 11. Vista Outdoor is a lucrative conglomerate that operates numerous brands in both shooting and non-shooting sports. Vista also owns the ammunition brands CCI, Federal, Estate Cartridge, and Spear, in addition to Remington. It also carries brands unrelated to the arms industry, such as Bell bicycle helmets and Camelback hydration goods. Additionally, it features the Bushnell brand, which produces binoculars, golf rangefinders, and rifle scopes. Apart from producing ammunition, Ammo Inc. also owns ArmBroker.com, an online marketplace for purchasing and selling weapons, such as assault rifles, semi-auto arms, and AR-15s. Although it is possible to order arms online, the weapons are not transported directly to private residences. Instead, they are shipped to nearby arm dealers for pickup and background checks. It is substantially larger than Ammo Inc. Vista Outdoor. Vista Outdoor revealed quarterly revenues of $403 million and $2.22 billion for the full year on May 6. Ammo Inc. announced quarterly revenues of $24.2 million and yearly sales of $62.5 million on June 29. Ammo Inc. had significant growth, reporting a 409% increase in quarterly sales and a 300% increase in annual sales over the previous year. More significantly, Ammo is not profitable while Vista is. Ammo recorded an annual loss of $14.55 million, but Vista declared net gain of $266 million for the same period. However, Wagenhals, who declared on July 8 that he anticipates Ammo Inc. to make its first net profit during the quarter that ended June 30, believes that this will change. On August 16, the business will make those earnings public. On July 29, Vista is expected to release its quarterly financial results. On July 27, Olin, the manufacturer of industrial adhesives and the owner of the Winchester ammunition brand, will release its financial results. Even if demand finally declines, retailers and economists warn that it may take some time for the supply of ammunition to catch up despite the industrial expansions. The issues that were present last year are still having an impact on ammunition availability, stated Mark Oliva, Public Affairs Director of the National Shooting Sports Foundation, an industry association. Ammunition manufacturers anticipate that these current market conditions will persist for a duration of 1 or 2 years.
The ban is likely to remain in effect while the case is still pending. A federal judge struck down the California law, the judge ruling that law was unconstitutional,
ending the mag ban. Measure 114, which was approved by Oregon voters in November, outlawed the production, distribution, and use of mags that could store more than 10 rounds of ammunition. The law mandated background checks and weapon safety courses in addition to permits for arm purchases. Additionally, it restricted the number of rounds that arm mags could store. Users were still able to maintain mags that could carry more than 10 shots, but they could only use them so much before they had to be changed permanently. The Charleston loophole, a federal statute that permits the sale of arms without a background check if it takes more than 3 days to complete, was closed by the law. In a federal action, the plaintiffs argued that the Second Amendment had been violated, among 6 other constitutional objections. The state contends that the Bruin judgment established shall-issue permitting systems, which mandate that the person in charge of the permitting procedure grant licenses to applicants who satisfy the requirements. The Supreme Court in Bruin cautioned against putting states in a regulatory vice by holding that in cases involving extraordinary societal concerns or drastic technological advancements, the types of laws that will be sufficient to demonstrate the nation's long-standing tradition of regulating arms should be considered as questions of comparison rather than exact correspondence. The state will provide proof regarding the prevalence of arms, especially high-capacity mags, and their application in mass slayings. The judge in the bench trial will make a decision based on the arguments put out by the state court and the plaintiffs. With expert testimony from both sides, state police and local law enforcement testimony, and the interests and objectives of the plaintiffs, the state trial scheduled for the fall is probably going to be comparable. The permit to purchase policy in Oregon is being questioned because it might be interpreted as a shall issue licensing procedure or as a violation of due process rights, since it prohibits individuals from exercising a fundamental constitutional right. The U.S. Supreme Court rendered the ruling in a New York case last summer, directing lower courts to evaluate challenges to arm control legislation based on a newly established text and history standard. In determining whether a restriction is consistent with the nation's long-standing history of arm control, courts must determine if the plaintiff's requested behavior is protected by the Second Amendment. In his deposition on behalf of the plaintiffs, professional shooter and sales executive Mark Hanisch stated that mags with a capacity of more than 10 rounds are typical. He acknowledged that he owned shares in Ammo Inc. valued at more than $1 million and that he had worked for companies that sold large-capacity mags for more than 18 years. The Surefire website has ads for high-capacity mags and other arm accessories, while Scott Farron, an attorney for the Arms Safety Alliance, viewed. Hanisch contended that since people benefit from having the upper hand in self-defense, Surefire should be allowed to provide them with high-capacity mags. It is anticipated that the Portland Federal Court will hear arguments for several days over the validity of arm laws passed by voters in a case launched by organizations that support arms. Judge Karen Immergut of the U.S. District Court directed the parties to reply to over 24 legal queries, such as whether handarms are bearable arms and if mass slayings are a historically high level of public concern. Both investigations seek to address the new standards that the U.S. Supreme Court established in last year's ruling in New York State Rifle and Arm Association v. Bruin. The new arms safety regulations in Oregon, which were adopted by voters in the autumn, have been upheld by the Oregon Supreme Court. The nation's history of regulating weapons and arms to enhance public safety is consistent with the court's ruling that prohibiting large-capacity mags and requiring permits to purchase arms are appropriate. The court's decision to narrow the scope of the trial, which lasted a week, resulted in a shortened case. The arm rights organizations had planned to provide proof of how Measure 114's permitting procedure would infringe on the constitutional rights of those who want to buy arms. The court rejected those claims, citing the possibility of harm from information regarding the law's possible future application.
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
The main question at trial was whether the state may limit the number of rounds a mag can hold to 10. Adam Johnson, Jessica Harris, and Brad Lowry, the sheriff of Sherman County, the plaintiffs, gave testimony regarding their personal arm-related experiences, as well as the law enforcement background of their families. Among the many experts summoned by the plaintiffs was Mark Hanisch, a longtime veteran of the weapons industry and vice president of sales at Timney Triggers. The nation's history and custom of regulating particularly harmful aspects of weapons and arms to safeguard public safety, the court determined, are consistent with the ban on large-capacity mags and the requirement for a permit to purchase a handarm. The conservative majority on the Supreme Court ruled that no one should require further authorization in order to use their Second Amendment right to carry an arm outside of their home. With 50.6% of the vote, ballot measure 114 was approved in November. Since then, lawsuits against the law have been brought by arm control organizations, sheriffs, and owners of arms stores. A state court judge stopped the law's implementation in January. The mag restriction section of the law was the main focus of the federal trial. Many lawsuits have been filed against Oregon's Measure 114, including the Arnold B. Brown case filed by the governors of Goa and the United States. The law prohibits the future sale, acquisition, and transfer of weapons deemed to have a considerable capacity. Due to difficulties in implementation, the state has been sued multiple times to stop its implementation. The permitting scheme was first put on hold for 30 days by a federal court judge in Oregon, but the mag ban was permitted to take effect right away. A complete temporary restraining order was obtained by Judge Robert Rocio of the Circuit Court for Harney County, stopping the implementation of the mag ban and the permitting regime. Judge Rocio reaffirmed his order to temporarily halt the permanent scheme and granted a preliminary injunction against the state's mag ban at a hearing on a motion for a preliminary injunction in state court. Meanwhile, the introduction of Oregon's arm legislation was shadowed by federal cases that were still unresolved and needed to be resolved. The federal lawsuit judge affirmed Oregon's mag prohibition and the permitting process after an accelerated hearing. She emphasized two crucial queries. One, is it possible for Oregon to limit law-abiding residents' access to arms to 10 rounds before necessitating reloading? And two, is it possible for the state to mandate that everyone buying an arm receive a permit that covers safety instruction, a background check, and assessment of mental health status? The judge contended that mags holding more than 10 rounds are not equally protected and therefore not appropriate for self-defense. She acknowledged that there might be legal justifications for arm ownership besides self-defense, which is why she supported the ban on mags on this ground. In this decision, the court has narrowed the meaning of the Second Amendment by stating that it safeguards a person's right to possess an arm that is typically employed for self-defense. She disagrees with this view, nevertheless, since the user's subjective intent is insufficient to show that an arm or attachment is primarily used for lawful purposes, particularly self-defense. Notwithstanding the difficulties, there is some good news in the Arnold State Court case. Judge Rocio granted a preliminary injunction against the mag ban, providing a glimmer of hope for those wishing to challenge the Oregon restrictions.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
Unanimous decision on banning mag. California's ban on high-capacity mags has been upheld by the 9th U.S. Circuit Court of Appeals, which ruled 7-4 that the statute solely limits the size of mags that can be used with rifles and not any particular weapon. The court argued that the restriction saves lives and only slightly infringes upon the fundamental right to self-defense because there is no proof that anyone has ever been unable to defend their family and home because they do not have a large-capacity mag. Due to nominations made by the former President Donald Trump, the U.S. Supreme Court is leaning farther to the right, which is why pro-arm organizations want to file an appeal with the court. Judge Patrick Bumate of the 9th Circuit, a Trump appointee, claims that large-capacity mags are commonly used by Americans for self-defense. He said that these mags are standard on the most popular arms sold today and are lawfully owned by millions of people across the nation. The 9th Circuit majority chose the more stringent approach, ruling that intermediate scrutiny was permissible because the ban only slightly interfered with the Second Amendment's guaranteed basic right to keep and bear arms. Arm rights activists hope the Supreme Court will select a lower legal standard for Second Amendment cases in its impending decision on a New York concealed weapons law. A verdict along these lines is more expected in the ongoing New York case. The majority ruling of the court, according to legal experts, rightly concluded that the Constitution, properly understood, does not prevent Americans from enacting the arm laws they want and need to protect their families and communities, and it does not entitle people to weapons of war. This assertion was made by Jonathan Lowy, the chief attorney for the Brady Arm Control Advocacy Group. According to New York law, candidates for unrestricted concealed carry permits had to convince a state licensing officer that they truly needed to defend themselves. Most applicants received unrestricted licenses, which are only good for specific activities. The ruling clarified the process by which courts must now decide whether regulations are permissible under the Second Amendment, requiring them to abide by standards that are comparable to, but limited from, those that have generally been established throughout American history. Arm control activists were concerned that New York's concealed weapons statute did not meet these standards. At least 6 states, the District of Columbia, New York, California, Hawaii, Maryland, Massachusetts, and New Jersey, will be immediately impacted by the decision. The ruling permits states to impose arm prohibitions in sensitive places, which may go beyond conventional examples of these locations, such legislatures and courts. According to Tom King, president of the New York State Rifle and Arm Association, the state chapter of the NRA, if authorities tried to ban arms from subways or buses, he would file legal challenges and would prefer to see as few places designated as sensitive as possible. A number of lower court rulings that had supported arm control measures have been overturned by the U.S. Supreme Court. These rulings include the prohibitions on assault-style rifles in Maryland, large-capacity ammunition mags in New Jersey and California. The court's historic ruling increased each person's right to bear arms, and it returned a number of cases to lower courts for additional review.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've gotten a lot of criticism over this. So why is it not a machine gun?
The conservative justices sided with the majority in the 6-3 ruling that struck down New York State's ban on carrying concealed weapons outside the home, while the liberal justices dissented. The ruling clarified the standard by which courts must determine whether restrictions are permissible under the Second Amendment to the U.S. Constitution, requiring them to be equivalent to those that have generally been implemented throughout American history. Arm control advocates are concerned that if courts use this standard, more arm regulations may be ruled unconstitutional across the nation, according to legal experts. Notwithstanding opposition to the Supreme Court's arm control decision, supporters say that the legislation's numerous restrictions will withstand legal challenges. Since the decision, judges have consistently upheld the federal statute that forbids convicted felons from possessing arms, and the Supreme Court said that circumstances involving unprecedented societal concerns or dramatic technological changes may require a more nuanced approach. Arm rights and arm control groups are keeping a careful eye on a number of ongoing challenges, including those that contest state statutes that prohibit certain semi-auto arms and high-capacity mags. Following the Supreme Court ruling, some arm laws were passed. For example, Delaware's order banning the enforcement of provisions in a new law governing the possession and manufacture of ghost arms, and New York's new arm law, which forbids carrying a weapon in public parks and places of worship. A different court denied a challenge to California's ghost arm restrictions. The arm mag publisher KCI filed a Second Amendment case in Nevada, and the Supreme Court is now deliberating it. The outcome might have a big impact on all companies who produce arms. Based on its goals, there are worries that the present administration wishes to erode these safeguards. The background of this case includes a slaying incident on August 4, 2019, involving one of KCI's mags. It was discovered that the person who provided the slayer with the mag was in possession of an arm illegally and had lied about owning an arm. KCI filed a motion for the lawsuit to be dismissed on the grounds that its mag meets the requirements to be considered an arm component and is therefore entitled to protections and immunities under the Protection of Lawful Commerce and Arms Act. KCI contends that since it might go beyond what the authors of the Constitution intended, the Supreme Court ought to step in and decide in their favor. They argue that permitting the lower court to proceed with the case defies the primary goal of the PLCA, which is to dismiss claims before they become drawn-out litigation or require costly discovery procedures. California Penal Code 32310 PC prohibits the manufacturing, importation, sale, or possession of large-capacity mags in an effort to curb armed violence.
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
Concerns arise as largest North American civilian ammo producer changes hands. As we watch, our world leaders will not stop talking about a shortage of ammunition and how difficult it is to keep up with what is happening in Europe. Both North American and European ammunition producers will tell us that it is difficult to keep up, and while many of those cases involve weapons, bear in mind that they use the same raw materials and components. For example, if you run out of primers for small arms ammunition, you will undoubtedly run out of primers for 155mm shells. We have a reliance here in the U.S. on our private ammo manufacturers, but as it turns out, the largest civilian ammo producer in North America, Vista Outdoors, has just sold all of their ammo manufacturing plants. Not some of them, but all of them, including well-known brands like CCI, Speer, Federal, Remington, and HeavyShot. These have been sold to a 30-year-old Czech billionaire. Here's why we are concerned. 1, we're really hanging on by a thread. If there was any sort of panic moment where civilian U.S. civilians went out and bought a bunch of ammo, it would disappear quickly, and it's not going to be replenished.
Obviously, they're gone, but will be an inspiration for us to do more. I'm not going to sign this bill into law.
Post-Bruin challenges have succeeded in lower courts. The opinions and reasonings therein have been grossly mischaracterized.
That's all for this video, folks. See you next time.